Welcome back to the Constitutional Clarion. After each Australian federal election, there's a period of 40 days during which candidates or voters can challenge the outcome of elections in particular electorates or in a state or territory in relation to the half-Senate election. The election writs were returned on the 12th of June 2025, so any petition challenging an election must be initiated by the 22nd of July. Such challenges most commonly argue that a candidate was disqualified or occasionally that the election was invalid due to illegal practices. The first challenge off the blocks this time is to the very close election in the federal seat of Bradfield. The argument concerns whether ballot papers were correctly treated as formal or informal. The margin of victory in that electorate was just 26 votes, with the independent Nicolette Boele defeating the Liberal candidate Giselle Kapterian. In this video, I'll explain the nature of the challenge, the relevant law involved, and how a court has dealt with a similar challenge in the past. Ms. Kapterian released a statement explaining her challenge, saying that we are requesting a targeted final examination of a small number of line ball ballots that were reserved and considered by the Australian Electoral Officer during the counts. She made it very clear, appropriately in my view, that the case did not raise any questions regarding the integrity of the electoral process. She said that the whole process had only served to reaffirm her faith in Australia's democratic institutions and that she expressed her gratitude to the Australian Electoral Commission for its tireless work. There are no allegations of wrongdoing, just arguments about different interpretations as to whether ballot papers are formal or informal. The rules on formality are set out in Section 268 of the Commonwealth Electoral Act. In a House of Representatives election, a ballot is informal if it has no vote indicated on it, or it does not indicate the voter's first preference for one candidate and an order of preference for all the remaining candidates. There is a saving provision if a voter has indicated a first preference and an order of preference for all remaining candidates except for one where the square is left blank. If that's the case, the blank square is deemed to be the voter's last preference. But the square has to be completely blank for that to apply. A vote is also informal if it has any unauthorised mark or writing on it by which a voter can be identified. The reason for this is that in the days before the secret ballot, electors were sometimes bribed to vote in a particular way. Whether they fulfilled their promise could be seen and heard when they voted orally before a crowd. Later, when ballots were first used, it was still possible to find out how a person had voted if they'd put their signature or initials or a mark on their ballot, which could be seen by scrutineers. To wipe this out, the law requires that there be no identifying words or marks put on the ballot paper. The main problem is that sometimes when people make a mistake on the ballot paper, they cross it out and then initial the changes that they make. But in any case, given the size of electorates these days, a court in 2008 considered that initials on a ballot paper would not identify an elector because plenty of other electors would have the same initials in that particular electorate. Section 268, subsection 3, says that a ballot paper shall not be informal for any reason other than the reasons specified in this section, but shall be given effect to according to the voter's intention, so far as that intention is clear. And that's the problem. Identifying whether the intention is clear and whether the voter has satisfied the requirements of Section 268. In this case, Kapterian's petition to the Court of Disputed Returns states that during the counts in the electorate of Bradfield, there were disputes over the formality of 795 ballot papers. They were ultimately reserved during the recount under Section 279 B of the Commonwealth Electoral Act for the Australian Electoral Officer for New South Wales, known as the AEO, to make determinations about. Under the law, the AEO is sent parcels of these reserved ballot papers and opens them in the presence of a public servant and any scrutineers who choose to attend. The AEO then assesses the formality of the ballots in accordance with the requirements of the Act and must mark on each of them the words admitted or rejected before they're returned to be either added to or rejected from the recount. The Australian Electoral Commission has published online its Ballot Paper Formality Guidelines for any of you who want to take a closer look at how this works. And the pictures that I have used of ballot papers in this video are taken from those AEC guidelines. Within those 795 determinations, it's claimed that the AEO wrongly rejected at least 56 of the reserved ballot papers where they indicated a preference for Kapterian over Boele. The petition then lists those claims. For example, it says that 3 ballot papers were rejected because the Australian Electoral Officer was not satisfied that the figure 2 in one square was distinguishable from the figure in another square. The petition claims that each of these decisions was made even though the 2 figures were distinguishable, and it was clear from the ballot paper as a whole that the voter intended to indicate a first preference for one candidate and an order of preference for all the remaining candidates. Other ballots had been rejected because the numbers marked were not discernible, meaning that they were illegible squiggles that didn't resemble a number. But the petition claims that the numbers were discernible when looking at the ballot paper as a whole. The petition also claims that at least 93 ballot papers were wrongly admitted to the count when the numbers were not sufficiently distinguishable or discernible, and that 2 ballot papers were wrongly admitted because they contained a mark or writing by which the voter could be identified. The petition concludes by alleging that by incorrectly making these determinations, the AEO contravened Section 279 B subsection 7 of the Commonwealth Electoral Act, which amounts to an illegal practice under the Act. Now, you might think that an illegal practice would be confined to things that are criminal or malicious in nature, like bribery or fraud or deliberately cheating in the election. But the Federal Court held in the earlier case of Mitchell and Bailey No. 2 from 2008 that a bona fide mistaken assessment of the formality of a vote does amount to a contravention of Section 279 B and therefore constitutes an illegal practice. The unfortunate term illegal practice, which the judge in Mitchell and Bailey criticised as being misleading, is not intended to reflect upon the integrity of the officers who make these difficult, contested calls about ballots, as indeed Kapterian accepted. Section 360, subsection 3, states that the power of the Court of Disputed Returns to declare that any person who was returned as elected was not duly elected, or to declare an election absolutely void, may be exercised on the ground that illegal practices were committed in connection with the election. But Section 362 says that where the illegal practice does not involve the candidate, the court shall not declare an election void or that a person was not duly elected unless it is satisfied that the result of the election was likely to be affected and that it is just to do so. So the petitioner needs to be able to establish that any mistakes in relation to the formality of votes was likely to affect the outcome of the election. Right, well, what happens next? The petition is made to the Court of Disputed Returns. That can be comprised of a single judge of the High Court, or indeed a full bench of the High Court, or the High Court can refer the matter for trial in the Federal Court. In this case, as the challenge is largely about interpreting poor handwriting of numbers on ballots rather than legal issues, there's a good chance that it will be shunted off to a Federal Court judge who will then, under Section 354, have all the powers and functions of the Court of Disputed Returns. How would the court then deal with the matter? Does it only consider the formality of those ballots disputed by Kapterian in her petition, or does Boele get to identify other disputed ballots from amongst the reserved ballots? Or does the judge have to make determinations about all of them? And does the judge have to make a fresh independent assessment on the merits, or does he or she have to be satisfied that the AEO in making the assessment had acted unreasonably or otherwise unlawfully? These matters have previously been addressed by Justice Tracy in that case of Mitchell and Bailey No. 2 back in 2008. So it's a useful guide as to how a court is likely to address the same issues today. Justice Tracy, after considering earlier authorities, decided that he had to undertake merits review of the ballot papers. But which ones? In that case, there were 643 reserved ballot papers that had been ruled on by the AEO, and the petitioner, Rob Mitchell, challenged the outcome in relation to 146 of them. Justice Tracy allowed the respondent, Fran Bailey, also to dispute the assessments made in relation to the reserved ballot papers. She identified 140 that she considered had been wrongly accepted or rejected. Once both parties had inspected the ballots challenged by the other side, the petitioner accepted the arguments of the respondent in relation to 82 of them, but disputed the other 58. The respondent accepted the petitioner's arguments in relation to 16 ballot papers, but disagreed in relation to the other 130. Now, this narrowed the field somewhat, but the court also identified a further 6 ballot papers about which neither side had made claims, but which the court wanted to hear submissions about. This was because the court could not find the election void or change the outcome unless satisfied that the result of the election was likely to have been affected by illegal practices. It therefore needed to make an assessment in relation to all the reserved ballots. What principles apply when making that assessment? Justice Tracy, following earlier judicial authority, decided that there were 2 cardinal principles. That the ballot, being the means of protecting the franchise, should not be made an instrument to defeat it, and that, in particular, doubtful questions of form should be resolved in favour of the franchise where there is no doubt as to the real intention of the voter. He added that there are 3 subordinate principles which help in giving effect to the cardinal principles. They are: 1. When seeking to determine the voter's intention, resort must be had exclusively to what the voter has written on the ballot paper. 2. The ballot paper should be read and construed as a whole. And 3. A voter's intention will not be expressed with the necessary clarity unless the intention is unmistakable and can be ascertained with certainty. A court of disputed returns must not resort to conjecture or the drawing of inferences in order to ascertain a voter's intention. And again, that's the problem. On the one hand, the decision maker should err in favour of giving effect to the intention of the voter so that their vote is counted. But on the other hand, the voter's intention has to be clear and unmistakable, and the court can't resort to conjecture or inferences. But the whole reason that these ballots were reserved for the decision by the AEO is because there was doubt about them. So in many cases, that clarity will be missing. You can probably see why now this is quite a difficult assessment to make, and reasonable minds may differ in relation to disputed ballots. For example, If you look at this sample from the AEC guide, they reckon that that tiny mark outside the bottom square reasonably resembles a 7, whereas I'd actually be pretty doubtful about that. And this is why it's really hard to predict the outcome of such challenges. How long will all this take? Well, Section 363 capital A has the rather hopeful heading, "Court must make its decision quickly." But the actual section says it must make its decision on the petition as quickly as is reasonable in the circumstances. If the court is making assessments about 795 ballot papers and each side has to be given the opportunity to make submissions about them, well, it might take a reasonably long time. This leads to the question of whether Nicolette Boele can sit in Parliament in the meantime. Parliament commences sitting next week on the 22nd of July. And the answer to the question is yes, she can be sworn in and sit in Parliament because unless the Court of Disputed Returns says otherwise, she has been elected as a member for Bradfield and her name is on the returned writ. Finally, what kind of order is likely to be made? The court has wide discretion in relation to the orders, which I mentioned earlier. And Section 364 says that the court shall be guided by the substantial merits and good conscience of each case. As this petition is only directed at issues concerning formality of ballot papers and not other issues that raise doubt about whether the outcome can be determined, such as lost ballot papers, for example, it's likely that the court would decide whether the respondent was validly elected or whether the petitioner was instead elected. There would probably be no need to declare the election as void and require a fresh election. That's so unless the margin became so small that other factors could then render the outcome unable to be determined. For example, the AEC has noted that in Bradfield, 2 voters who fell into that category of the elderly or confused appeared to have voted twice. If, after determining the formality issues, the margin was so tight that those extra 2 votes could have affected the outcome, then it might be necessary to void the election and have another go. But let's hope it doesn't come to that. Thank you for watching the Constitutional Clarion. I do hope this helps you to impress your family and colleagues with your newfound familiarity with the ins and outs of this challenge and the importance of writing numbers clearly on your ballot paper. And as always, I look forward to seeing you again next time. Goodbye.